Hi, hello, how are you all? Welcome to my channel Law Made Simple with me Vidya Reddy. Today in this part 3 of interpretation of statutes, let us learn the classification of statutes, how on what basis they are classified. So, the primary duty of the judiciary is to interpret the statutes. Law may be customary law or judge-made law or statutory law. Obviously, statutory law needs interpretation if there is any ambiguity. So, the statutes are classified based on the duration, method, object and extent of applications. On the basis of these four references, the statutes have been classified. Let us look into the picture of one by one on which basis these statutes are classified. Coming to the classification with reference to duration. Obviously, duration means time. A statute may be classified on the basis of the duration of how long it is going to be in operation. They are classified as temporary and permanent statutes. Obviously, temporary statutes has some validity. So, a temporary statute is one when its period of operation or validity has been fixed by the statute itself. So, an act continues in force unless repealed earlier until the time so fixed. After the expiry of the act, if the legislature wishes to continue, a new act may be passed. So, it is as simple as such. So, temporary statute has some validity time and it is been fixed in the statute itself. What is the example of this temporary statute is the Finance Act is a temporary act because it is required to be passed every year. Coming to the Permanent Act. A permanent act is the one where no specific period has been fixed for its operation or validity. As such act will be in operation until it is amended or replaced by another act. So, as simple as the definition. So, temporary has a validity, permanent doesn't have any validity in the statute itself unless it is replaced or amended by the legislature. So, what is the permanent statute? The Arbitration Act was in force until it is repealed in 1996. A new act has come in 1996. So, the IPC, CRPC, CPC, Indian Contract Acts, Industrial Disputes Act, these are all permanent acts until they are amended or repealed. So, these are based on the duration. Coming to the second classification with reference to method. On this method of classification, we have two types, mandatory or obligatory statute and directory or permissive statute. As per the definition itself, we can directly say that mandatory has certain rules and regulations to be followed. A mandatory statute compels the performance of certain things. It compels certain things must be done in a certain manner or form. A mandatory provision has to be strictly observed and their omission has been held fatal to its validity. So, we have an example of Workmen's Committee Compensation Act. It is a mandatory act and it is the responsibility of the employer to pay compensation if section 3 is satisfied. Hence, it is a mandatory statute. While coming to the directory statute merely directs or permits the things to be done without compelling its performance. The omission of such provisions may not result in the hardship of the administration of justice. So, the directory statute is not as strict as the mandatory statutes. So, coming to the example of a directory statute, the Arbitration and the Conciliation Act 1996 is one of its example and doesn't compel the parties to go for arbitration. Similarly, the provisions of particular legislation may be either mandatory or directory. And the mandatory statute, there may be a directory provision. So, as in the case of directory statute, there may be a mandatory provision. So, this is the classification based on the method. The third classification is based on the classification with reference to object. We have certain statutes which are classified on the basis of object like codifying statute, consolidating statute, penal statute, taxing statute, repealing statute, amending statute, remedial statute, declaratory statute. All these statutes are according to their definitions. We can easily classify based on its object. Coming to the fourth classification with reference to extent of application. So, with reference to extent of application, we have two kinds of statutes. They are public statutes and private statutes. Obviously, refers to the definition itself, meaning itself. A public statute is one which relates to the matter of public policy, and the statute may be general, local or personal in nature, like Companies Act, all the Indian penal codes, IPC, CRPC, these are all again classified under public statutes. A private statute relates to the matters which are individual in nature and it is related to a body which is not in public consequence. Like acts relating to private trust, adoption, these all belongs to private issues and this is a private statute. So these are the basis of classification of the statutes. What are the four bases of the classification? We have classification with reference to duration, method, object and extent of applications. As such, we have come to the end of the video. It's riddle time. Please answer the riddle in the comment section. Please like, share and subscribe my channel for many more interesting topics. Thank you.